Today's topic is sexual harassment of women at workplace and its remedies. My name is K. Umesh Rao. This topic is also covered under labor law 2. In this class, we are discussing the definition of sexual harassment and what is the redressal mechanism of women in the workplace and what is the meaning of conciliation, inquiry into the complaint, action during pendency of enquiry, what is enquiry report, what is employer's duty during sexual harassment case, what is the meaning of internal complaints committee, how the constitution of internal complaints committee and local complaints committee is made. Sexual harassment of women at workplace. The Sexual Harassment of Women at Workplace Prevention and Prohibition and Redressal Act 2013 was passed by the Parliament and it came into force with effect from 9th December 2013. The Act provides for protection of women at their workplace from any form of sexual harassment and for redressal of any complaint. Why this Act was formed? The Act was formed on the basis of guidelines laid down by the Supreme Court in its judgment Vishaka versus State of Rajasthan. Now, what is the meaning of sexual harassment? What is the definition of sexual harassment of women at workplace? So, sexual harassment has been defined as unwelcomed acts or behavior, namely physical contact and advances, demand or request for sexual favors, or making sexually colored remarks, showing pornography, or any other unwelcome conduct such as physical, verbal, non-verbal conduct of sexual nature. In addition to that, sexual harassment includes many things as detailed below. Actual or attempted rape or assault, unwanted deliberate touching, leaning over, cornering or pinching, unwanted sexual teasing, jokes, remarks or questions, whistling at some time, kissing sounds, howling and smacking lips, touching an employee's hair or body, touching or rubbing oneself sexually around another person. Third one is, among other things, following incidents occurs in relation to the act or behavior of the sexual harassment. What is that? Implied or explicit promise of preferential treatment in her employment. Here, officer, boss says that you will be promoted out of the way, out of the term. Second one, implied or explicit threat of detrimental treatment in her employment. Officer says you will be terminated. Implied or explicit threat about her present or future employment status and interference with her work, creating an intimidating work environment, creating an offensive work environment, creating a hostile work environment, humiliating treating likely to affect our health and safety. Now, redressal mechanism. What is the redressal mechanism adopted by the women at workplace? If sexual harassment in workplace occurred, what woman has to do? Woman has to make a complaint in writing. Complaint should be filed before whom? Complaint should be made to whom? Complaint has to be made to the committee. This committee is appointed by the employer. There are two types of committee. One, internal committee. Second, local committee. Every employer of a workplace shall have to constitute a committee called Internal Complaints Committee. Committee consists of members. Sometimes establishment have less than 10 workers or complaint is directly against the employer. In such cases, district officer constitute a district committee that is known as local committee. So in big unit, internal committee, small unit, it is local committee. Is there any time limit for making a complaint? Yes. Complaint shall be made within 3 months of the incident. If series of incident happens of a person is harassing more than one, then 3 months from the date of last incident, 3 months time can be extended, and provided they should explain the circumstances under which it was not filed. If women cannot make complaint in writing because of illiteracy or any other reason, what happens? The committee shall give assistance to the woman. Sometimes legal hair can also make a complaint when in case woman is unable to complain due to mental physical incapacity or death of a woman. Now conciliation. What is the conciliation? The internal committee is formed. The committee, before making an inquiry at the request of the aggrieved woman, takes steps to settle the matter between her and the respondent through conciliation. But in this conciliation, no monetary settlement shall be made on the basis of conciliation. Committee record the settlement arrived and forward the same to the employer or officer to take action as specified in the recommendation. Committee shall provide copies of settlement to the agreed woman and respondent where the settlement is arrived at. No further enquiry shall be conducted by the committee. Inquiry into the complaint. Now, in any organization, there are two types of persons. One, respondent is an employee of the establishment. Then, in such cases, inquiry shall be conducted as per the service rules applicable. Second category, respondent is not an employee or such service rules, no such service rules exists. Then employer has to forward the complaint to the police station within 7 days for registering the case. The agreed woman informs the committee, it may be internal committee or local committee. The terms and conditions of the settlement arrived has not been complied with the respondent. Then committee will proceed to make an inquiry into the complaint and send the complaint to the police. In some cases, both the parties are employer. In such cases, personal hearing should be given during the course of inquiry. Copy of the findings shall be made available to both the parties. This is to help the parties to make representation against the findings before the committee. When the respondent is convicted of an offence, the court may order payment of such sum to the aggrieved party by the respondent. Powers of the internal committee or local committee. They have the same powers of the civil court in respect of following matters. Committee can issue summons. Committee can enforce the attendance of any person. Committee can examine the person. Committee go for discovery of documents and production of documents. The inquiry shall be completed within 90 days. Now, action during the pendency of the inquiry. During the pendency of inquiry, committee may recommend to the employer either transfer the aggrieved woman or respondent to some other place. In such cases, if you are transferring a woman, grant 3 months leave to the woman, but this leave should be in addition to the normal leave. Other than the leave, grant relief to the aggrieved woman. So, employer shall implement the recommendations of the committee and send the report of such implementation to the committee. Now, we are discussing about inquiry report. What is inquiry report? Inquiry committee shall provide a report to the findings to the employer in case of internal committee. He shall provide report to the findings to the district officer or district collector in case of local committee within the period of 10 days from the date of completion of the inquiry. When the allegation against the respondent is not proved, what order can be done? Then committee shall recommend the employer in case of inquiry, internal committee or district officer in case of local committee that no action is required to be taken in the matter. So, when the allegation against the respondent is proved, what to do then? Committee shall recommend to the employer to take action for sexual harassment as misconduct as per the provisions of the service rules and deduct from the salary of the respondent and pay it to the aggrieved woman or legal heirs. In some cases, what happens? Employee is absent from duty or his employment is not existing. What to do then? Then employer may direct the respondent to pay such sum. If the respondent fails to pay the sum, what to do? The committee may forward the order to the land revenue district officer and ask him to recover the sum as the arrears of land revenue. The employer or district officer shall act upon the recommendation within 60 days of the receipt of the committee. In the sexual harassment case, there are some duties to the employers. What is the duties of employer? What is employer's duty? Employer has to provide safe working conditions in the work from persons coming in contact at the workplace. Employer has to displace the penal consequences of sexual harassment and order constituting a internal committee in any important place in the workplace. Employer has to organize workshop and awareness programs at regular intervals. Employer has to sensitize the employees regarding the provisions of the Sexual Harassment at Workplace and Provision and Redressal Act of 2013. Employer has to conduct orientation program to the members of the internal committees. Employer has to provide necessary facilities to the internal committee or local committee. So employer has to assist in securing attendance of the respondents and witness before the internal committee or local committee. Employer has to make all such information to the internal committee or local committee with regard to the complaints made. If a woman wants to file a complaint in relation to the sexual offense, employer has to provide assistance to the woman. Employer has to assist the victim and help her to initiate action under Indian Penal Code against the offender. Employer has to treat sexual harassment as a misconduct and initiate action under service rules. Timely submission of reports by employer is also necessary. Employer has to monitor timely submission of reports by the internal committee. Now, internal complaints committee and constitution of internal committee, how it is constituted? Every employer of a workplace shall, by order in writing, constitute a committee called Internal Complaints Committee, where in the office or administrative units of the workplace located in the place. So, the internal committee shall be constituted at all the administrative officers. Now, internal committee shall consist of members, committee, presiding officer. She shall be a woman employed at the senior level at working place amongst employees. She should be a senior level woman. Suppose, in case senior level officer is not available, then what to do? Then presiding officer shall be nominated from any other officers of the same workplace. Okay. Suppose in this case also, in other offices also of the workplace, if senior level officer doesn't have, then the presiding officer may be nominated from any other workplace of the same employer or other department or other organizations. And not less than 2 members amongst employees committed to the cause of the woman or who had experience in the social work or legal knowledge. And not less than 2 members amongst non-government organizations or association, they are committed to the cause of women or person familiar with the issue relating to the sexual harassment. So, half of the total members so nominated shall be women. Term of the office, presiding officer or member of the internal committee shall hold office not exceeding 3 years from the date of the committee, from the date of the nomination. Non-government organization members shall be paid fees by the employees. Removal. How to remove the presiding officer or member? Presiding officer or member, if he contravenes the provisions of the act, if he is convicted of an offense, if he is found guilty in disciplinary proceedings, he has abused the position against the public servant, public interest, he will be removed. Now, constitution of local committee. You know that local committee is committed where the establishment have less than 10 workers, or if the complaint is against the employer, then district officer shall constitute a district committee known as local committee. Government notify district magistrate or additional district magistrate or collector or deputy collector as the district officer. The district officer shall designate one nodal officer in every block, taluk, area, municipality to receive complaint and forward the same to the concerned local committee within 7 days. Now, members of the members of the nominated by the district committee. Chairperson. Chairperson is nominated amongst eminent women in the field of social work and committed to the cause of women. One member nominated among women working in block, taluk, ward in the district. Two members, at least one should be women from non-government organization committed to the cause of women with legal background. One member belong to SC, ST and other backward class. Ex officio member. Who is ex officio member? Office of the Social Welfare and Child Development in the district. Term is 3 years. Removal, same condition. If he contravenes the provisions of the rule, who? Member or chairperson. If he is convicted of an offence, if inquiry of the offence, if he is found guilty in any disciplinary proceeding or disciplinary proceedings pending against him, he has abused his position and his continuation is prejudicial to the public interest, then they will be removed. Thank you.